So, good morning, all of you. So, today we have a lot of news to discuss. So, let's begin. So, the first news today is regarding the FCRA bill. So, we will try to discuss what is the FCRA bill and what is the opposition regarding this bill. So, there is an article which presents the both sides of the FCRA bill. So, there are two articles basically, one in the for and one in the against. So, we will try to discuss both the articles one by one. So the first article is by the opposition leader, Dr. Shashi Tharoor. So reading the article, it says that the FCRA bill, that is the Foreign Contribution Regulation Amendment Bill, it reintroduced in the Lok Sabha for adoption during the monsoon session following its sudden withdrawal in April, marks a dangerous escalation in the centralization of executive power in India. So basically, this bill was earlier introduced in the budget session, but as it could not be passed in the budget session, now it is being reintroduced in the Lok Sabha. So Dr. Tharoor says that this bill can basically lead to centralization of executive power. Centralization means where the power gets concentrated into one hand. So it says that now power will be concentrated into central executive. In the name of enhanced transparency and regulatory oversight, the proposed legislation fundamentally rewrites the relationship between the Indian state and civil society. So basically, this bill is regarding the foreign donation which comes to the NGOs and the civil societies in India. So this bill is basically to regulate that. So Dr. Tharoor says that even though the bill proposes transparency, but basically it will change the relationship between the Indian government, Indian state, means Indian government, and the civil societies in India. So driven by its majoritarian ideology and allergy to independent voices, the current government has increasingly reframed the non-profit charities, think tanks, and human rights groups not as development partners but as source of subversion and foreign manipulation. So basically, as this bill controls the foreign donation to civil societies, NGOs, and think tanks, so see, there was an MHA report which says that around 700 or many NGOs, they are involved in anti-national activities like subverting the infrastructure development and other activities. So Dr. Tharoor says that it's not good. So we should consider that those organizations, basically the civil societies or the think tanks, as development partners of India, and not something which is as a tool in the hands of the foreign enemy countries or foreign governments to subvert the infrastructure development of India. To neutralize these voices, the state has targeted their primary vulnerability, dependence on international philanthropy. So Dr. Tharoor says that these organizations, basically civil societies, your NGOs, or the think tanks, they depend upon foreign contribution for their sustenance, and basically controlling their source of funding might lead to like inefficiency or might lead to subversion in their activities. Through aggressive enforcement and sweeping amendments to the FCRA, the government has already imposed complex compliance burdens such as banning sub-granting to grassroots organizations, slashing allowable administrative outlays, and mandating a single bank branch in New Delhi for all foreign inflows. So basically, what government is doing? Suppose there's an organization A. Now it receives a fund from, let's say, some international organization, let's say X. Now, earlier, what used to happen, this big organization A, suppose it receives 100 crore rupees, it used to sublet this amount, or it used to basically devolve this amount to smaller organizations working in the hinterland of the country, let's say small a, small b. So 10 crore it will give to this, 10 crore it will give to this. Now, as per the new amendments, this is not possible. The organization which receives the foreign funding, they can only use it. They cannot devolve the fund further to smaller organizations. So this is the first change proposed. Second, it says that the administrative outlays. Suppose there is an NGO. Now that NGO has two expenses. One is the administrative expenses, other is the operational expenses. For example, there is an NGO, let's say regarding education, which works in the field of education. So the amount of money it basically spends for education, that will come under the operational expenses, and administrative expenses are those expenses like the salary of the staff, etc., are the administrative expenses. So basically, the government through this amendment is saying that there needs to be a cap over administrative expenses. like suppose 100 rupees an NGO receives, so not more than, let's say, 20 rupees can be spent over administrative expenses. Majority of the amount has to be spent for the purpose for which it is received. Okay, that is the second change proposed. Third, it says that every NGO which receives foreign funding will have to basically maintain a bank account. Will have to maintain a bank account in a single bank in a branch in New Delhi. The resulting regulatory squeeze has triggered an 87% drop in foreign funding, forcing thousands of secular and community-based organizations to shut down, while an impending legislative push to allow the state Caesar to cancelled NGO assets threaten of permanently cripple the sector. So basically, here Dr. Tharoor presents a data that because of these impending changes, there has been a decline of 87% in foreign funding for these organizations. So, for the nation's welfare network, and particularly for the long standing Christian institutions that form the backbone of healthcare, higher education, and social care across states like Kerala, the provisions of this bill do not merely represent administrative hurdles, they present an existential threat to institutional autonomy, property rights, and constitutional freedom. So basically, there are many Christian organizations in India which receives foreign funding, and these Christian organizations they run many charitable hospitals, schools, etc. So he talks particularly about the state of Kerala. So he's saying that because of this, these welfare activities might take a hit. The amendment introduces an unprecedented mechanism of control that bypasses traditional legal protection. The bill establishes a central, bureaucratically appointed designated authority empowered to take control of an organization's foreign funds and physical property. So the thing which he mentioned in the first part, that is centralization of executive power. So that is what he is discussing here. If an entity's FCRA license is suspended, cancelled or denied renewal, its asset provisionally vest in this authority, granting the government the statutory right to seize, manage, and ultimately sell these properties while crediting the proceeds directly into the corporate fund of India. So, see what is an FCRA license? If you have an FCRA license, means you can receive foreign funding. In order to receive foreign funding, you need to obtain an FCRA license from the Ministry of Home Affairs. So, if as per Dr. Tharoor, if the FCRA license is cancelled by the government or it is not renewed further, in that case, the assets of that NGO or of that organization can be becomes the property of the government, and government will have the right to sell that property, and whatever proceeds come, it will be transferred to the corporate fund of India, even if an asset was only partly funded. Furthermore, under newly proposed mechanism of deemed cessation, if an organization fails to submit its renewal application on time or its renewal is rejected by the Home Ministry, its registration automatically ceases, immediately terminating its right to operate, utilize tied assets or excess remaining foreign funds. So basically, there is a term called deemed cessation. It means that if an organization basically fails to submit whenever the license is due for renewal, if the organization fails to submit the renewal application or the application is cancelled, in that case, the registration of that NGO or of that organization will be automatically cancelled. So that is the meaning of deemed cessation. And once the registration is cancelled or once the license is cancelled, in that case, the government will have the right to basically take control over the assets of that organization. At the same time, the excessive reserve the authority to dictate rigid timelines for the receipt and disbursement of funds, stripping charities of the financial flexibility required to manage long-term infrastructure projects, disaster reserves, or endowment. Basically, it says that the executive reserves the authority to dictate rigid timelines for the receipt and disbursement of fund. So when the fund can be received once, so suppose 100 crore rupees an NGO receives for basically, let's say, education purpose. Now, as per the current bill, it will have the government will have the right to say within what timeline this 100 crore rupees has to be disbursed by the NGO. Now, as per the author here, it says that it basically curbs the autonomy of the organization to basically autonomy to decide when to spend the money. Certain organizations, what they do, they reserve certain funds for contingency purpose. Now, that autonomy will be lost because of this bill. To understand the human toll of these provisions, just examine their impact on regions with deeply rooted institutional networks. As a Kerala MP, I have seen Christian run charitable trusts, school hospitals, diagnostic centers, medical colleges, and welfare NGOs serving marginalized population regardless of caste or creed for well over a century. So he's talking about his own state where there are many Christian organizations. They are running charitable hospitals, schools, etc., where people of every strata of society, irrespective of their caste, creed, are basically catered to. Now, these facilities rely on a mix of local contribution, domestic fee, and foreign grants to maintain a world-class medical equipment, sponsor affordable care, and the educational scholarship. So basically, they said these charitable organizations which run these hospitals, schools, etc., they have three sources of their funding. One is the local contribution, that is a domestic contribution. One is the fees which they charge for the minimal fees which they charge for the hospitals or school, and third is the foreign grant which come, and because of that only they are able to maintain a world class basically infrastructure. Now, by linking an administrative decision on an FCRA license directly to the physical confiscation of land and building, the bill creates an environment of extreme instability. A single administrative delay or an adverse ruling by the Ministry of Home Affairs could instantly convert a functioning 500-bed charitable hospital into a state property, basically disrupting essential public services and placing community assets under government control. So basically, as we understood, he says that there can be an administrative delay in filing the application, or there can be an administrative fault whereby the Ministry of Home Affairs cancels the FCRA license. In any such event, the property and the assets of those organizations, like the hospital they are running or the education institution they are running, it will become a government property. It will come under the government control. Now, if an institution's FCRA license is suspended or withdrawn under the proposed framework, its legal recourse is severely restricted, forcing non-profit into protracted and costly litigation through writ petitions under Article 226 in High Court or Article 32 in the Supreme Court. So basically, if let's say the FCRA license is cancelled or renewal is not granted, in that case the only recourse these organizations will have is go through the legal route under article. So basically, they can file a writ petition under Article 226. We know that under Article 226, writ petitions can be filed in the High Court, or under Article 32, which is the right to constitutional remedies, the writ petition can be filed in the Supreme Court of India. Okay. So, the constitutional challenges could rest on Article 300A regarding the right to property, as taking over legacy assets created partly through foreign and partly through domestic funds without fair compensation or stringent judicial safety safeguards constitutes arbitrary deprivation of property. So, Article 300A basically talks about the right to property. So, we know that earlier it was a right to property was a fundamental right under Article 19, but by the 44th Constitutional Amendment Act, it was transferred to Article 300 capital A, which is now basically a constitutional right but not a fundamental right. Challenges may also arise under Article 14, given that the bill mandates that law enforcement must seek must seek must seek central government's clearance prior to initiating investigation, risking selective enforcement that shields favored entities while applying draconian measures against minority-run organizations. So he raises a doubt here that these laws may be used against institutions which are run by minority community, like the Christian community in this case. There can be a selective application of this law. This is the fear raised by Dr. Tharoor in this article. Furthermore, by choking the financial lifelines of these institutions, the administration circumvents core constitutional protection, specifically the right to freely practice and propagate religion and acquire, manage denominational property without formally repealing them. So he says that by doing so, government is trying to circumvent fundamental right given under Article 25 and Article 26. So Article 25 and Article 26 comes under the broad fundamental right, which is right to freedom of religion. So Article 25 says basically the right to freely practice and propagate religion, and Article 26, which is a denominational right, which is given to religious denomination, it talks about the religious denominations will have the right to acquire and manage property. So basically, the author is here saying that the government is trying to circumvent this fundamental right without, actually repealing them. So they are bypassing this fundamental right. So in practical terms, if a hospital's license is suspended, the trust must immediately seek an emergency stay order from the High Court against physical eviction by the designated authority, while simultaneously defending its registration before the Ministry of Home Affairs, a process that drains charitable resources away from patient care and education. So he's saying that if, let's say, the license is suspended, so in that case the organization will have to take a legal route, which is a very expensive affair, and the money which was meant for charitable purposes will now be spent in legal processes, etc. So it is profound injustice to subject institutions that have devoted generations to India's development, education, and healthcare to such punitive statutory mechanisms. So he's saying that it is unfair for those institutions that they have been working for long for the development of India. The contributions of the church and affiliated charitable organizations in India are documented in millions of lives uplifted, educated, and healed. To treat these developmental partners with institutional suspicion and subject their physical assets to executive expropriation undermines the principles of constitutional democracy. So basically, saying that we should see these organizations not with an eye of suspicion, rather we should consider them as developmental partners. The selective enforcement fundamentally violates the foundational liberal tenet that a democratic state must remain a neutral arbiter rather than an instrument of political engineering. So basically, he's raising the suspicion that it is not clear in the law anywhere. So just a suspicion that there can be a selective application of the law. So the law does not say it per se, but it is just the interpretation of the author that it can be that law is being selectively enforced against the minority institutions. So if it is done so, he is saying that it will be a dent on the democracy of India. So then the author says the ruling party uses the cover of regulatory legality to assault liberal policies, transforming our humane constitutional democracy into a rigid state structure of majoritarian control. Again, it's just an inference of the author that the law can be selectively applied, which is again not good for our the constitutional morality of India. The bill must therefore be resisted through every legal and democratic channel available, beginning on the floor of the parliament. When it comes up for discussion in the Lok Sabha, the opposition must stand united in its resistance, demanding at an absolute minimum that the bill be referred to a select committee for rigorous clause-by-clause consideration, public consultation, and input from civil society stakeholders. So he's saying that whenever the bill comes to Lok Sabha, so right now the bill is in the Rajya Sabha, so whenever, it has been introduced in the Lok Sabha, so whenever the bill comes, so he is demanding that the bill should be basically referred to a parliamentary select committee. What is select committee? There are two types of committee, we know that. One is select committee, other is joint committee. Joint select committee is, if the Lok Sabha creates a select committee, there will be only members from Lok Sabha in that committee, and if the joint committee, there will be members from both the houses, Lok Sabha and Rajya Sabha. So he is demanding that the bill should be referred to a select committee. Okay, and also for in the committee stage, the bill is basically the bill is scrutinized clause by clause. Every detail is scrutinized. Expert consultations are done. So a better scrutiny takes place over the bill in the committee stage. So he is demanding for this. Okay, so this is one view of the FCRA bill which we are seeing, by which he is saying that there can be a selective application of the bill, and he is raising apprehensions regarding it. Now let's look at the other side of the argument. So here is an article by Mr. Vinay Sahasrabudhe. So he starts with Thomas Friedman once said that the world is flat. Globalization has indeed created a level playing field for trade and industry. So why does Thomas Friedman say that the world is flat? Because he's an economist. He's a basically liberal economist who says that basically he was favoring the globalization, and he says that because of globalization now there is a level playing field. Oh, every country can trade with each other. So that's why he gave this quote that world is flat. However, when forces try to make the world socially and culturally flat, it amounts to making it less beautiful. The globalization of philanthropy illustrates its danger. So he says that, see, the world should be flat economically. There should not be any economic boundary, but it should not create basically a social, and the world should not be made socially and culturally flat, because every society has their different their different culture, and it should not be made uniform. So he says that basically the globalization of philanthropy, basically philanthropy matlab the basically the charity which comes, so that the foreign fundings and all, they try to basically create that flat world of like socially and culturally flat world. So as Parliament prepares to debate amendments to the FCRA, many civil society groups have criticized the proposed changes and leveled serious allegations against the government. But India's experience with foreign funded activism, along with examples from other countries, offer enough reason to revisit the regulatory framework. So he said that there are experiences where basically these NGOs have been found halting infrastructure development and all. So he cites those historical example, basically telling the necessity of this bill.
Over time, genuine voluntarism has given way to professional activism. So he says that there are something called genuine voluntarism. Basically, what is the meaning of genuine voluntarism? Basically, suppose I am a tribal living in a forest. I'm a tribal living in a forest, and let's say that forest is being cut. So if I protest against that, that's something genuine. That's something genuine because I am the one who is impacted by it. But now he's saying that this genuine voluntarism is giving way to professionalized activism. Professionalized activism matlab, it means like now there are professionals who are ready to basically to oppose every infrastructure development or developmental activity of the government. Organizations once known for commitment, sacrifice, and grassroots engagement increasingly adopted the NGO model with access to large donor funding, reshaping priorities. So, organizations, NGOs, which were earlier basically, they were grassroots, they were actually working for the development of people. Now they are turning towards NGO model with foreign funding. That is the argument which is given by the author here. Some evolved into influential actors that sought to shape public policy, at times reflecting donor agency more than the local needs. So he's saying that these NGOs, they basically work at the behest of the donor agencies, the foreign agencies which are contributing, which are from which they are receiving contribution. So basically they are perpetrating their idea. So whatever their idea of public policy is, the same they are trying to propel here in India because of the foreign funding which they are receiving. The rapid expansion of foreign funding encouraged this shift. The experience of other countries is instructive. So he's putting the foreign international examples. So what has happened in other countries because of this foreign funding? In 1997, scholar James Petrias, writing on Latin America, argued that foreign funding NGOs have become adept at designing donor-driven projects while promoting the rhetoric of identity and globalism. So he's taking the example of Latin America, where he's saying that in Latin America there was a news that these NGOs which are receiving foreign funding, basically they are speaking the words of their foreign donors. He said that this fostered dependence on external funding, aligned organizations with neoliberal priorities, and weakened genuinely autonomous grassroots movements. So basically, because of this, what happens? The grassroots movements which are genuine in nature, they are at times subverted. Researchers in Africa have also pointed out that aid flows have created a vicious cycle of dependency that is proving hard to dismantle. There is also research in India showing that foreign aid does not have a significant impact on poverty alleviation. So he cites research that it says that the foreign aids, there are no verifiable argument which says that because of foreign funding there has been poverty alleviation in India. Now this is not to point fingers at every funder. So he says that not every funder is bad. Now there is no need to ban foreign funding. So he says that the bill is not banning foreign funding. It's not that foreign funding is banned altogether. No, foreign funding is not bad. He says tighter scrutiny is essential in the interest of the community, donors as well as the recipient. He says that just the funding should be scrutinized from where the funding is coming. That is the aspect where we have to basically put a regulatory control. So the bill is not against foreign funding. The bill is not against foreign funding. Basically, it talks about we have to regulate from where the foreign funding is coming. Seen this way, the FCRA amendments are aimed at increasing the framework's transparency and making it risk ready. So he's saying that because of this FCRA, this Foreign Contribution, Regulation Act, so there will be transparency. People will get to know from where the funding is coming, which organizations are funding, if some international organizations are funding or not. So that transparency will be there because of this FCRA. They seek to bring administrative clarity, improve monitoring of the use of foreign contribution, enable the identification of inactive association, fix accountability, and ensure that foreign contribution is used only for the purpose it was provided. So he says that because of this regulation, now the fund which is coming, let's say fund is coming for the purpose of education or for, let's say, for opening schools. So now it will be clear that whether the fund is being used for that purpose or not, or if it is being diverted for some other purpose, that clarity or that transparency will come because of this FCRA. These amendments will ensure that foreign money does not shape domestic, political, social, or ideological outcomes in ways that compromise national security and sovereignty. So, why this FCRA? He says that now we will be able to see if because of the foreign funding, some NGOs are working against the national security or sovereignty of this country. A Supreme Court judgment, in fact, upholds the state invocation of sovereignty and national security to regulate foreign contribution. So he says that even Supreme Court has upheld the idea that state can control foreign funding or regulate foreign funding in the interest of the national security or the sovereignty of this country. The relevant question is not the cost of compliance to an individual organization, but the source and purpose of foreign funding activity within India. Besides, the regulatory framework proposed is as per the international norms only. Sovereign states maintain comparable and frequently stricter control over foreign funding of domestic non-government activity. He says that it's not unique to India. Every country in the world, not every, like majority of the country in the world, they basically regulate the foreign fundings of these NGOs. The proposed FCRA amendments are both faith neutral and sector neutral. So he said that it is not targeting. So the apprehension which was raised in the earlier article, so it is nowhere in the bill. So it's just an apprehension that it will be targeted against minority institutions. So it is not like that. Even if a majority community institution receiving foreign funding, they will also be under the same scrutiny which a minority NGO or minority institution will be under. Now, they make no distinction between religious and secular organizations or among different faiths. While some groups have opposed the changes, most voluntary organizations, including hospitals, universities, research institutions, and service bodies, have not objected. So, he's saying that the objection is selective. Not every organization have objected to it. Only a few of them have objected. For organizations that use foreign funds transparently and for declared purposes, greater accountability poses no threat. He says that the organizations which are working genuinely, they are using the fund for the purpose for which it was received, actually they will have no issues, and they are actually in for a transparent regulation of these fundings. Had the amendments genuinely endangered the voluntary sector, resistance would have been far broader. He says that if there was a genuine threat to the NGOs, then the resistance which is coming, which is a very minority resistance right now, it would have been a broader resistance. Beyond FCRA, the government should also address the excessive professionalization of the sector. So the NGOs are no longer they are becoming professional. See, there are managers and all in the NGOs. See, NGO is basically about grassroots activity. Now it is becoming more professional. More managed by the managers. Now it needs to revive India's tradition of autonomous, community-driven voluntarism rooted in civilizational values. So he says that we need to go back to the grassroots movement which used to happen earlier, and not the professionally managed NGOs. So this is the second counterpoint which you are seeing. So whenever any question comes regarding FCRA, you can use both the viewpoints. So see, we have to be neutral. So both the pros and cons needs to be mentioned. Okay. Now another important news is money bill route pending before Supreme Court. Government chooses it to raise strength of judges. So the Rajya Sabha Wednesday passed the Supreme Court Number of Judges Amendment Bill 2026, which seeks to increase the sanctioned strength of Supreme Court judges from 34 to 38, including the Chief Justice of India. So currently there are 34 judges in the Supreme Court. There are 33 puisne judges plus 1 Chief Justice of India. Now there is a bill in the Rajya Sabha which proposes to increase this number to 38, basically 37 puisne judges and 1 Chief Justice of India. The bill which cleared Lok Sabha Monday was passed as a money bill, a route it has also taken in 2019, when the Supreme Court strength was raised to 34. So basically this is a money bill. So now the question comes, see, money bill is basically governed by Article 110 of the Constitution. So there are specific criteria which if a bill satisfies those criteria under Article 110, then only it will be called a money bill. But now this bill also has been called a money bill. Now, in 2018, a key dissenting opinion of the Supreme Court ruling had described this route as a fraud on the Constitution. So, in fact, in 2019 also, when the number of judges was increased to 34, at that time also, money bill route was used. And then a case was filed in the Supreme Court of India saying that money bill cannot be used to increase the number of judges. So, and but that judgment went in favor of the government. But the point is, at that time there was a dissenting judgment which says that it is like a fraud on the constitution. The statement of objects and reasons of the bill cites expenditure involved in creating 4 additional posts of judges. So what is the reason given why it has been chosen as a money bill? It is saying that because of raising the number of judges to 38, there will be more expenditure on the salary, perks and allowances of the judges. That's why it has been defined as a money bill. It says that this will increase the expenditure on account of pay and allowances on creation of 4 additional posts of judges in the Supreme Court along with required staff. The judges will also be entitled to the use of rent-free official residence. Each judge will have to be provided with personal staff at residence and office. Expenditure would also be incurred in connection with the deployment of security for judges. The estimated recurring expenditure on salaries of the 4 judges and their staff, conveyance and other miscellaneous expenses would be rupees around 10 crore 56 lakh 81,648 rupees per annum, and non-recurring expenditure towards car, furnishing of official residence and other miscellaneous expenses will be approximately rupees 3 crore 47 lakh 36,000. So there are recurring expenditure, non-recurring expenditure. Recurring, like, so the vehicle will have to be, non-recurring will be like the vehicle needs to be purchased, or the furnitures in the office or in the residence. So this is a non-recurring expenditure. Recurring expenditure like the staff, the salary of the staff, the salary of the judges, the security staff salary, etc. So there will be expenditure on those accounts. So that's why thus the total expenditure on creation of additional 4 posts of judges will be rupees 14 crore approximately. So that's why it has been, so because there is an angle of expenditure of money, that's why this bill has been basically touted as a money bill. The issue of whether a bill can be certified as a money bill is a case of question pending for consideration by a 7-judge constitutional bench. In 2023, the Chief Justice of India, then Chief Justice of India, D.Y. Chandrachud, had said that the case would be listed for hearing soon. However, the issue is yet to be taken up. So the case was filed, but the case is not yet taken up, whether this money bill route can be used for such purposes or not. Now, as I told you, Article 110 of the Constitution deals with money bill. A money bill is a bill that, in the opinion of the Speaker of the Lok Sabha, deals with taxation, appropriation of public funds, the Constituent Fund of India or the Contingency Fund of India. So Article 110 specifies whether a bill is a money bill or not. But the point to note here is, it is a decision of the Speaker of the Lok Sabha which is final in the event of money bill. If the Lok Sabha Speaker says that yes, the bill is money bill, it is final and no questions can be asked regarding that. And we also know that if you look at the money bill, a money bill can be introduced only in the Lok Sabha. A money bill can only be a public member bill because the prior recommendation of the President is required for the introduction of money bill. Rajya Sabha has very minimal role in the passage of money bill. Rajya Sabha cannot reject a money bill, cannot amend a money bill. Rajya Sabha can only recommend changes, and those recommendations are not binding over the Lok Sabha. And if the Rajya Sabha does not take any action over the money bill for 14 days, the bill is deemed to be passed by both the houses. Now when the bill goes to the President of India, even the President of India also has limited options. She can either give her assent or can reject the money bill or withhold her assent. She cannot send the money bill back to the House for reconsideration. So this is the polity part associated with money bill. So it is written here, a money bill can only be introduced in the Lok Sabha, and the Speaker categorizing the bill as a money bill means that it need not be passed by the Rajya Sabha. The union budget, for example, is a money bill. So the budget which is introduced, it's a money bill. Okay. Now, so any of the this we have done. Okay. This additional clause has been the basis for the Modi government to pass key legislations as money bill in its previous term. The opposition had argued that this was done only because the government did not have the numbers to get the legislation declared in the Rajya Sabha. So basically there is a clause Article 110 clause 1 subclause G, which says that any matters incidental to any of the matters specified in the articles 110 1 subclause A to F. So basically incidental. So even if the matter is not directly related about the expenditure of money, but even incidental, matlab if it is related to it also, then it can be classified as a money bill. And the opposition party have been saying that the present government has been using this Article 110 clause 1 subclause G, that is incidental to the matters. That clause has been used by the government to basically label these bills as money bills. And why it has been done so? because the opposition alleged that the government at that time did not have the requisite number in the Rajya Sabha to pass these legislations. That's why they were basically labeling them as basically your money bill. Now, the constitutionality of three major laws, including the Prevention of Money Laundering Act (PMLA), are yet to be examined by the larger bench in the light of whether these bills qualify to be passed as money bill. The other two are the Aadhaar Act and the 2007 amendment altering the service conditions of the tribunal. So there are three bills basically. One is the PMLA Act, one is the Aadhaar Act, and other is the other act which was passed in the 2017, which basically altered the service condition of tribunals. Now these three bills were basically certified as money bill, but there have been cases against that they do not qualify as money bill. Now constitutionally speaking, the decision of the speaker is final and no courts can basically interfere in that, but still petitions have been filed in the Supreme Court to basically examine whether these bills are money bills or not. While the PMLA and the Aadhaar Acts were substantially upheld by the court, the Supreme Court struck down the tribunal amendments as unconstitutional. The Supreme Court basically upheld PMLA and the Aadhaar bill as money bill, but basically the bill which basically altered the service condition of tribunals, that was struck down by the Supreme Court. However, in both rulings, the issue of money bill was left to a larger bench of. So whenever even if it was struck down, it was not struck down on the ground that the bill is not a money bill. It was struck down on other grounds. So the point that whether the bill is a money bill or not is still a point where the Supreme Court has not given any decision. Justice D.Y. Chandrachud, the lone dissenter in the Aadhaar ruling of 2018, criticized the government for passing the Aadhaar Act as a money bill. He had called it as a fraud on the constitution and subterfuge. The government had argued that since the subsidies distributed through Aadhaar flow from the CFI, the law is validly categorized as money bill. So in the Aadhaar judgment, it was the ex-Chief Justice of India, Justice D.Y. Chandrachud, who had called that Aadhaar bill cannot be called as a money bill. Why? Because he called it as a fraud on the constitution. But the government's argument was that using Aadhaar, many subsidies are basically disbursed in the country, and those subsidies comes out of the Concert Fund of India under Article 266 Clause 1. So that's why it is fair to basically certify them as money bills. Later, a 5-judge bench of the Supreme Court in 2019 struck down the law as unconstitutional for interfering with judicial independence. It referred the money bill aspect to a larger constitutional bench. So basically this tribunal law, it was struck down on the ground that it is basically interfering on the independence of judiciary. So on that ground it was basically rejected, not on the ground that whether the bill can be certified as a money bill or not. That aspect is yet to be decided by the Supreme Court of India. In doing so, the court also expressed doubt over the correctness of the 5-judge constitutional bench 2018 verdict upholding the Aadhaar Act, which had been passed as a money bill. So the issue of whether the bill can be classified as a money bill or not is yet to be decided by the Supreme Court, and pending the decision, government has passed another bill basically increasing the number of judges in the Supreme Court from 34 to 38 as a money bill. So that's all for today's discussion. We will talk further about the policy rates in the tomorrow's article in detail. Okay, thank you so much.